Righty, we're going on the record, Tony, on DC 226912, Grozier versus Perez Trucking. Counsel, make your appearances.
Marquette Wolf and Hunt Bonneau on behalf of the plaintiffs, Your Honor.
Matt Harper on behalf of Jago Public Company.
Jeff Seeberger for Weber LLC.
Tom Needham on behalf of the Perez Group of Defendants.
All right, let's proceed.
Good morning, Your Honor. Marquette Wolf again for the plaintiffs. This is a no evidence motion for summary judgment with respect to certain affirmative defenses, in particular that the decedent plaintiff was negligent in causing this accident. In this accident, the decedent was in a line of dump trucks. He was outside of his vehicle. Another driver of a dump truck driver backed over him, and he was killed in the event. The defendants have, in this motion, the burden to establish that the decedent violated a duty of care and that violation caused his death, essentially. And while they have the burden, I'd ask the court to focus on this issue. In order to establish that a breach of a duty of care existed and that it causes, the defendants have the burden to demonstrate through evidence in the record that this event was foreseeable to the plaintiff. What the defendant's responsive pleadings and what the record reflects is merely this, that it's kind of a woulda, coulda, shoulda, everybody ought to know, generally speaking. And there's affidavits that you'll hear where they discuss it's a belief. We have a belief that he should have known. And beliefs and generalities do not meet the burden to establish that, in this case, Mr. Grozier could foresee what was about to happen to him. Speaking in generalities and beliefs don't establish evidence in this record that this event was foreseeable. And I think that the failure to present in this record competent evidence as to foreseeability is fatal to the affirmative defenses that the plaintiff was negligent and comparatively responsible.
Okay, response?
Yes, this is Matt Harper with Jago Public. I'm at the Wolf Law Firm. As you know, Your Honor, in a no evidence summary judgment motion, the court must view evidence in the light most favorable to Jago and disregard all contrary evidence and inferences.
Mr. Harper, I've dealt with
Pharmacy Inc. versus Hapner, which is cited in our brief, Your Honor.
Mr. Harper, can you hear me okay?
Huh?
Can you hear me okay?
Yes, sir.
Yeah, I'm familiar with the summary judgment standard. You don't need to.
Okay. So let's go to foreseeability. We have testimony that's cited in our brief that working in a active work site, not paying attention to the safety policies that are in place that, by the way, Mr. Grozier knew about. He used to work for Jago, and so he knows the policy of if you get under your truck, you don't stand 6 feet away from your truck in the blind spot of the somebody backing up. Other things that he did not adhere to, and this goes to the summary judgment, Your Honor, is cited in our brief, and I just kind of want to highlight them. He wasn't practicing 360-degree awareness, which means, as we cite in our brief, testimonies like put your hat on a swivel, be aware, of somebody backing up, be aware of somebody in a skid steer turning around. And he did not do that. He was standing 6 feet away on the back of his truck near his cab. We have testimony on that side in our brief. And he was in the blind spot of Mr. Perez, who owned it, or who was a worker and owner for Perez Trucking, that backed over him. He was out of his truck, like I said, standing on the side of his cab, which is prohibited by the safety policies of both Jago and Weber, and he was turning his back to the traveling public or traveling job site. We can tell that by the way his body was positioned after the unfortunate death of Mr. Grozier. And a Jago employee told Mr. Grozier to get back in his truck when the job started. Mr. Grozier did not adhere to this advice. He got in his truck and got back out, standing just kind of unaware of what's going on. The medical examiner found amphetamines in his system, methamphetamines. We don't have an active, we don't have a amount because of the situation of the death. But as you can imagine, and it's documented, that being intoxicated by methamphetamine makes you take risks. It's well known. He was not wearing a hard hat, which is definitely in the Jago safety policies. You must at all times wear a hard hat. And not that a hard hat would keep him from dying in a rollover, but a yellow hard hat will make him more visible to Mr. Perez, who's backing around his truck. And Mr. Grozier did not heed the backup alarm or the honks of Mr. Perez. We have testimony that there was a backup alarm present. There's kind of some conflicting testimony on this, which makes it a question of fact, Your Honor, that the backup alarm was not working. Some people on the site said they couldn't hear it. The Department of Transportation found that it was operational. So did OSHA when they investigated the truck after the accident. And some people didn't hear it. It's an active job site, so there's a lot of noise going around. But Mr. Grozier was right there. He must have heard that. He must have heard somebody telling him, get back in the truck. He must have known. He worked for Jago before he worked for Robert Perez Trucking. And situational awareness is part of the safety policy. He knew that. We have multiple evidence. We have multiple periods of testimony that says situational awareness is important. And as far as foreseeability and proximate cause, we have testimony from lots of people saying, if you don't follow the safety policies at work, it's a life and death situation. And we cite that in our brief. There's many more quotations I can cite if you ask me to. But he knew it. It's life or death. Everybody recognizes that. So it's foreseeable that if you don't follow the safety policies, you may get hurt or killed. And so for that reason, Your Honor, we have tons of evidence that creates a reasonable doubt or reasonable cause for our defense or for affirmative defense of contributory negligence. And I ask that the plaintiff's motion be denied.
May I respond, Your Honor?
Sure, go ahead.
On the issue of 360-degree situational awareness, the suggestion is made that Mr. Grozier should be able to see in every direction all the time, all at once. That doesn't make sense, and that's non-evidentiary. The issue is whether he could foresee it. The suggestion that, well, Mr. Grozier could foresee it because he used to work for Jago and he was trained specifically on these issues. As evidence to support that claim, the defendants attached their exhibit number 1. That's the affidavit of Ricky Lemons. And in it, they say, here's how we train our people, and Grozier was one of our people. But there's no evidence that Grozier was ever trained. Instead, what they submitted was a form that included an employee acknowledgement. None of this has anything to do with Mr. Grozier. None of this is signed or acknowledged by Mr. Grozier. What we have is a defendant saying, we would have done this, we should have done this, Maybe they could have done this, but that's not evidence that any of this was ever done. So the idea that because he worked there, he must have known doesn't show that he did work there and did know, was trained, did receive this training. So suggesting that by virtue of being employed is evidence he got this training, that's not evidence at all. If he had training, they would need to produce evidence that he was trained. They haven't produced that. They merely produced the suggestion. You have another affiant saying, I believe he should have known. That's not evidence. Anyone's belief is not competent summary judgment evidence. It's just conclusory. This suggestion that methamphetamines, there's no causal connection between a positive drug screen, which would require expert testimony establishing a dose and a dose response that might affect or have any causal connection to this event. And there's no evidence of that. There's no evidence at all supporting it. It's just hey, this drug showed up in his system, and that's all we have. That's not evidence of foreseeability. Without actual evidence of it, it becomes hey, he should have known, he could have known, he would have known. We will concede that there's conflicting evidence on the backup beeper. The eyewitnesses say they never heard it. Someone else says it was working. And that's as far as they go. There's no evidence that he heard it. He has to hear it. And the eyewitnesses, there's no witness to say he heard it. The eyewitness testimony is they didn't hear it. So the only thing that if it worked, it wasn't effective. And that doesn't create foreseeability on the decedent's part. And that's our response, Your Honor.
Let me ask a question. Actually, let me hear from the other defendants if they have any comments.
Nothing further from the Perez defendants, Your Honor.
So let me just ask a quick question. So have you guys submitted a binder on all the briefing on this particular motion?
We submitted, this is Matt Harper for Jago Public. We didn't send a physical binder, but we sent the motion with all the evidence in electronic filing. We can certainly send a binder if that's what you request, Your Honor.
Yeah, if you don't mind sending a binder that includes both sides briefing on this.
Yes, sir.
And this is different than the motion that was filed last week, correct?
Yes, Your Honor.
That's still under advisement. So
wait, say that again, Your Honor. It's different from what?
The motion from last week.
Yes, sir. It's different.
Yeah.
Can I respond to counsel's arguments?
Yeah, that's fine. But let me just finish with this. So you can give me a binder that includes both sides briefing with highlighting cases from both sides, or at least the cases from both sides. I don't need anything involving the summary judgment standard, but any other cases that are cited that are critical to the reasoning. You may want to consult with each other. And if you could get that to me by Wednesday.
Yes, Your Honor.
Mr. Harper, go ahead.
Yes, hold on. Let me write this down. By Wednesday. Okay, this 360-degree awareness suggestion, that's well known in the industry. Everybody has suggested that you have to have awareness around a job site, an active job site. There are dump trucks backing up. You have to keep your head on the swivel. We have that testimony. There creates a question of fact whether he did or did not. We have direct testimony that he was not. And so that creates a question of fact whether he was adhering to 360-degree awareness. It's not about whether he was trained on it. I mean, if you think about it, Your Honor, you're on a job site with trucks backing up. Aren't you going to keep your head on the swivel? Everybody says you should, whether it's written down or not. That's common sense. And as far as the expert testimony from the drugs, I mean, Your Honor, we have an ME certificate that defendants have seen that shows he had amphetamines in his system. Whether it affected his cognizant ability at that point, we don't have the drug levels because it was a bad accident. But it raises a question of fact whether the amphetamines created a situation where he's not following correct awareness that would contribute to his injury or death. As far as the foreseeability, no death or injury, there's nothing written down. I mean, once again, you're in an active construction site. You have dump trucks backing up left and right. We have people saying in our brief, and we didn't put it in the foreseeability section, but we put it in the last couple of pages of our brief, Your Honor, that people have testified that following safety rules and keeping these distances and keeping situational awareness, wearing your hard hats, it is a question of life and death. Life and death is foreseeability. Everybody admits to it. That creates a question of fact, whether Mr. Grozier was contributory negligent or not. And with that, I'm done.
All right, I'm going to take this under advisement. I'll try to get you a decision within 3 weeks. Anyone have any questions? And you have a trial setting coming up when again on this?
Your Honor, I think
I
it's
think it's in August, Your Honor.
August, okay. Yeah, August 13th. Okay. All right, we'll try to get you a ruling within the next 3 or 4 weeks. So you guys
All
have
right, we'll get you
a
binder
great
by Wednesday, Your Honor.
I appreciate it. Thank you so much, Mr. Harper. You guys
Thank
have
you.
a great rest of your day, okay?
Thank you, you too,
All right,
Judge.
thank you.
Thank you. Okay. All right. Is anyone here on the Husak case?
Yes, Judge. Simon Whiting for Dr. DeMaio.
Good morning, Your Honor. Christian Havens on behalf of the plaintiff.
Morning, Your Honor. Alicia Voltmer on behalf of the defendants, Baylor Scott and White Health and Health Texas Provider Network.
Okay, so we have a status conference to talk about a special setting. Is that correct?
That's correct, Judge.
Okay. When did you guys want to specially set it?
Judge, you had offered us some dates in the hearing last week, which unfortunately did not work for the parties. And so we requested some dates in May and June from Rhonda last week. But I think towards the end of the week, we got a response saying pick any Tuesday in May or June, but there was some confusion as to whether that was indeed what you intended or not.
So June, like next month you're talking about? Okay, let me
No, 2025, Judge.
Why are we bumping this all the way to 2025?
You offered us dates in March and April of 2025 last week.
Okay.
Hearing. And so because those dates didn't work, we then went to the next possible setting that you had available.
All right, what dates do y'all have available? What date can you guys agree on? And I'll let you know if it's available.
Judge, certainly from Dr. DeMaio's standpoint, the 13th, at least the, yeah, sorry, I'm just flipped over 1 month too far. The 13th, the 20th, the 27th of May all work for Dr. DeMaio, and all of those dates in June on the Tuesday, first Tuesday, 10th, 17th, 24th, all work for Dr. DeMaio.
All right, everyone else?
I would just need to confirm with the two defendants I represent, Your Honor. I think if we have a number of those dates, I'm sure we can agree if those Tuesdays are available.
Okay. That isn't that kind of the purpose of this hearing, though, is to try to figure out what date there is. I mean,
Yes,
I don't want to have hearing after hearing on this. Do you not have a corporate rep that's available?
And not with me at this hearing, Your Honor, I don't.
Why don't you call them and figure out if that, I want to set this and I don't want to keep redoing this. So do you talk to your client? That was the purpose of this hearing. What about for the plaintiff?
Yes, Your Honor. Any of those dates in May that were proposed by Mr. Whiting work for plaintiff, the 13th, the 20th, or the 27th. The only date that does not work is the 3rd of June.
So the June dates are available as well.
The 10th and the 17th
Okay.
and the 24th.
All right, Mr. Waltmer, Ms. Waltmer, go ahead and call your client, make sure those are, what dates are good out of those.
I am texting her right now, Your Honor.
Okay.
Your Honor, I also called and got voicemail. Can we not just, with the dates that Mr. Havens and Mr. Whiting have just given, can we not just submit our agreed scheduling order with the date?
Because I have 1,200 other cases. That's why I really tried to bend over backwards to try to accommodate you guys. That's why we have this hearing. But it's up to y'all to talk about what dates you're available. If you submit an agreed order and I've had another special setting set in the interim, then I'd have to have another hearing on this. That's the purpose of having this hearing so that we can talk through. That's why you're supposed to have dates that are available. I'd given you dates. Have you guys not communicated in the last week about this?
We communicated about the first round of dates that you gave that did not work. But after that, no, I didn't see any circulation of additional dates.
All right, why don't you guys just stay on the Zoom until you hear back from your client? I need to set this on a particular date, and with a special setting, I stopped setting other cases. If this wasn't a special setting, I'd be fine with your approach, but with the special setting, I need to know that all parties are available, and I don't have another special setting that week.
Understood, Judge.
All right, why don't you guys stay on the Zoom, and you guys can there's someone named Sam Bavafa who's raising their hand. Who's that?
Yes, Your Honor. Your Honor, apologize for interrupting. I was just saying I'm here for a different case, but I've taken a break from a deposition to be this hearing. If the court can hear my case as well, I would appreciate it.
Sure. Let me. Why don't you guys, Ms. Waltner? Why don't you call your client and see if you can't get a confirmed date so we can get this thing finished.
Yeah, I've called and got voicemail. I'm trying again, Your Honor.
Okay. And sir, are you here on a scheduling conference?
Yes, Your Honor.
Which one?
Mr. Arsalan Bashir is my client.
All right. And is opposing counsel here? Ms. Engelman? Okay. All right. You get to pick a date for the trial. When do you want it to be set for trial?
This is in it seems to me like in May or June of 2025 should be adequate time for discovery, Your Honor. So if I can have May or June of 2025, please.
Okay, what day would you like?
Um,
Open it
for
up.
right now for May, I only have one trial setting starting on the 5th, but the rest of May and June as of right now, I'm wide open, Your Honor. So whenever
The 5th of May.
yes, from the 5th to 9th, I'm busy, but they're trial sitting on May 19th, Your Honor.
Okay. How does May 20th sound?
Yes, Your Honor, that works for me. May
We start on
20th.
a Tuesday. So Rhonda, did you get that? Rhonda? Rhonda, are you there?
Your Honor.
Yeah.
She was opening the courtroom.
Oh, she was opening the courtroom. Okay. Thank you.
All right, I'm back. Go ahead.
All right. So this is, give me the cause number on this case again, sir.
Yes, Your Honor. The cause number is, I'm sorry, Your Honor. It is
I can find it. Give me a second.
Is this the Katie Hussock case?
No. This is it's on the scheduling conference document.
Your Honor, the cause number is DC-23-20141.
All right. And
Okay,
Rhonda,
Bazaar versus Sterling.
Yes.
yes. And we're going to set that for trial. What we just said, what, May 20th?
Yes, Your Honor.
May 20th. And who do you want to use as a mediator?
Your Honor, to be honest, I'm not very familiar with North Texas mediators. I've had a few good experiences with McCullough mediation. If that's okay with the court, that's fine.
Yeah. You want to use Mike McCullough?
Yes, or yes, Your Honor, that
Or
was
is there someone else there you like?
Terry Martin, if I'm not mistaken.
You want to use Terry Martin instead or Mike McCullough?
Terry Martin, please.
All right, Rhonda, go ahead and set this for mediation with Terry Martin and set it for trial on May 20th, 2024. And again, Engelman is not here, correct?
I don't see her, Your Honor. I don't see her in the Zoom setting.
Okay.
If
All
I'm
right,
not,
we'll get back to your deposition. We got everything taken care of. If you want to submit an agreed scheduling order, you can, but we'll go ahead and set this for trial on May 20th.
2025, correct, Judge?
2025, correct.
and Your Honor, before I leave, is there a mediation deadline?
That's up to y'all. Usually I say, just a week before trial. But if you want to do an early one, that's fine with me too. I don't care.
Okay. All right. Thank you, Your Honor. Thank you. May I be excused?
You may.
Thank you. Bye.
All right. Anyone here on Bonowitz versus Foster? Bonowitz versus Foster. Anyone here on that? Okay. Anyone here on, we're going through the scheduling conference docket. All right. McAllister versus AZZ Surface Technologies. Anyone here in that case?
Good morning, Your Honor. I'm here on behalf of the defendant in that case.
And Roy Reeves here on behalf of the plaintiffs, Your Honor.
All right, let's figure out a trial setting on this. When do you guys want to set this for trial?
Your Honor, are you, I noticed several of the previous parties were referencing May. Are you looking only in May? Are we looking at June dates available also in 2025? Or are you not stretching out?
No, I'm flexible. I don't mind setting it a little bit earlier too. April is pretty good. It's really up to y'all.
I've already double checked. Both April and May are good for plaintiffs, Your Honor, but we're flexible as well.
Your Honor, we had put together a kind of a proposed draft scheduling order with a May 12th trial date, which I could just push over to Mr. Reeves after the call if May 12th worked for the court and for Mr. Reeves.
Let me take a look real quick.
It's okay with our schedule, Your Honor, if the court's available.
So it'll be May 13th because we start our trial dockets on Tuesday. May 13th is great with us. So Rhonda, in this case, we're going to set it for trial on May 13th.
Okay.
And then let's pick a mediator. Who would you like as a mediator?
The plaintiffs would ask for John Brookman, Your Honor, with Brookman Mediations. He's always been available and successful.
I'm not familiar with him, but I'm okay with him. What about the opposing counsel?
Funny enough, that's the same name I was going to propose, Your Honor, so that's great.
John Brookman, how do you
Yes.
spell it? Bruckman.
Brookman.
And is he in Dallas or where is he? I've never heard of him.
He's in Fort Worth, Your Honor.
Oh, okay. You guys both Fort Worth guys, I guess.
I'm a Fort Worth.
He's never failed me, Your Honor.
All right. I don't, it's so Ron, did you get that? It'll be Jeff Brookman, Brookman in Fort Worth. Did you get that, Rhonda?
You said Jeff or John?
John.
Okay, I got it.
And I have a phone number if the court coordinator needs it.
Sure,
Yeah,
go
that would
ahead.
be great.
817-725-7070.
Thank you very much.
And it looks like, Mr. Reeves, that you showed up in person to the hearing. Just so you know, my Monday hearings are all remote, Friday are hybrid. So hate that you showed up to the courthouse unnecessarily, but
Yes, sir.
I know in Fort Worth, they're much more strict about showing up in person. I'm kind of want to let people save some money. I hate that you had to drive all the way over here, but just so you know, in the future, Mondays are all remote, Fridays are hybrid.
Yes, sir. Thank you, sir.
All right. Anything else you guys need to chat about?
Nothing for me, Your Honor.
Not today, sir. Maybe we'll be
Have a great
excused.
rest of your day. We're going to go ahead and set this for trial.
Thank you, Judge Hopper.
Thank you, sir.
No problem.
Your Honor, this is Alicia Voltmer. I have 6 dates from my client for the trial, special trial
Oh,
site.
good. Okay.
So the dates that we have are May 20, May 27, June 3rd, 10th, 17th, or 24th.
You guys, I think everybody said May 20th was good. Is that right?
That's correct for Dr. DeMaio, Judge.
That's what?
Yes, that's right. Good for Dr. DeMaio.
Good, good. I thought you said that was Cinco de Mayo, and I'm like, I don't think that's Cinco de Mayo, but maybe it's later that year. I don't know. I thought it was May 5th, but okay. And what about the plaintiff? May 20th, I think you said was okay.
That works, Your Honor.
All right, Rhonda, we're going to specially set the Husak case on May 20th. Did you get that, Rhonda?
I'm sorry. Especially said May 20th for the Husak versus Baylor.
Yes. And do you need the cause number for that, Rhonda, or do you have it?
No, I have it, but just for clarification, I have DC 23-17198.
All right. Anything else today, guys?
No, Your Honor.
No, Your Honor.
All right. I'm glad we got this all worked out. You guys have a great rest of your day, okay?
You as well. Thank you, Judge.
Thank you. All right. Let's try to finish up with the scheduling conference docket. Okay. I believe we just did McAllister, right? And Bashir. So is Open America or Open Works versus AGR? Anyone here on that case?
Yes, Your Honor. Good morning. This is Lamisa Chowdhury for Plaintiff Openworks.
And also Catherine Grozier for defendant AGR.
All right. When do you guys want to try this case?
Your Honor, this is a complex case. We believe that in November or October of 2025, a trial date would be appropriate for sufficient amount of time for discovery.
I think defendants are okay with that too, Your Honor.
That is really far out. And I mean far out in time.
Just for context, Your Honor.
Give me a little more detail because that is pretty far out. So why is this so complex? What is this about, I guess?
Sure, Your Honor. So this is a complex case involving implementation of complex software systems and it's multi-million dollars. There are multiple third parties who would need to be subpoenaed for depositions or trial testimony. There are dozens of witnesses who are current and former employees of both parties. So based on my prior experience on cases similar to this, I've had another case. It's been discovery's been ongoing for a year and a half. So I think any less than a year and a half on this before a trial date would be too aggressive.
Okay. Let's look at October at least. I'll give you any Tuesday in October. What do you want to do? That's November's just too far out.
Okay. I think October 21st of 2025 would be good.
Opposing counsel?
I think that we have a trial setting that week already in October.
Do you want to do the 14th?
We can do that.
Opposing counsel?
1 second, Your Honor, I'm just checking.
Or the 7th, that would you'd be kind of cutting it tight, I think, if you do the 14th or the 21st.
I'm just double checking the other trial date that we've got. 1 second. Yeah, because the trial date that we have in another case is the 14th of October. That's when the trial is supposed to start.
Okay, so you said the 14th, is that what you said?
Yes, Your Honor.
Oh, I thought you said, okay.
And I think it's supposed to last a week or so. But yeah, the 14th is.
How about the 28th then?
Yeah, I think that would be better for us.
That's fine.
All right. So we're going to set this for trial, Rhonda, on October 28th. And then who would you like to mediate with?
We talked previously. We haven't agreed on a mediator yet. Just for context, we've been throwing some names around. We originally, I think, proposed mediators out of Dallas, surrounding areas, and then plaintiffs proposed mediators out of Houston. I mean, we would prefer a mediator out of Dallas.
If you can't agree, it's going to be in Dallas. If you agree to somebody outside of Dallas, I'll do it. But I don't know the mediators in other areas as well. So she's going to use Dallas mediators. So this is a complex, large case. So, Chris Noland is really good at these kind of complex cases. I don't know if you've dealt with him before. Jeff Kaplan, they're both very expensive, but they're both very good. Is very good former magistrate judge. If you want someone with a computer background, I'm not sure what a mediator he is, but he's really knowledgeable about computer issues. Peter Vogel.
So we had thrown Mary Burden or Mark Gilbert out as proposed.
This is a commercial case.
Yes, Your Honor. That's the reason why we prefer not to mediate with Ms. Burden or Gilbert, because I believe that their experience is more in torts.
Yeah, definitely. Gilbert is so hard to schedule with. He's a great mediator, but I would say probably not Gilbert. Mary has done a variety of different things. She's semi-retired at this point, but she's still taking cases, I believe.
Judge, some of the names that we have proposed in Houston and also
we're not considering
Austin.
We're not considering it outside of Dallas without agreement. So you need to pick someone in Dallas.
Okay.
The other side wants to agree to somebody.
I was just going to say, if we are looking at Houston, if by agreement, Lemisa, we would propose. 1 second, I had two names out of Houston. I don't know what you feel about them. 1 second. What about Bob Black or Chris Voss? They are out of Houston, but I didn't know if you could agree to those two names.
I'm not familiar with them, but Judge, is there a way that counsel and I can confer?
Nope. We're doing it right now, so we're gonna pick a mediator. You can later substitute somebody else in. We're gonna pick a mediator today. So if you can't agree to someone, I would say, I mean, he's very expensive, but Chris Nolan on these complex commercial cases is probably the best in Dallas that I've heard of.
Okay. Judge, we would agree to Chris Nolan or Mr. Kaplan.
Do you have a preference, opposing counsel?
Yeah, give me 1 second. I'm just going to reach out to the lead attorney and just see which of those he prefers.
I mean,
It was
there's
Chris
others too.
Nolan.
Or
I'm sorry,
Judge,
Your Honor.
or Judge Kaplan are both really good.
Okay.
They're both very, very expensive, but if you want someone a little less expensive, maybe Judge Pfeiffer he's not quite as, I mean, he would be good as well.
What was Mr. Kaplan's first name?
Jeff Kaplan, he's a former magistrate judge.
I just texted the lead attorney. Sorry, was Chris Nolan, is he a former judge or magistrate?
Who?
Chris Nolan?
No,
Okay.
it's just Judge Kaplan.
Okay. I mean, we'll go ahead and we'll go with Chris Nolan.
Okay.
And then you said if we do agree on something else, we can always substitute.
By agreement.
Okay. All right.
And
then we're good with Chris Nolan for now.
Chris Nolan. All right. Rhonda, go ahead and appoint Chris Nolan on this.
Okay.
And
Trial date is set at 10/28/2025 at 9 a.m.
anything else we need to chat about, guys?
No, Your Honor.
I don't think so, Your Honor.
Okay.